laws replete with references on husband and wife.
Your Honor, the petitioners submit that these laws, such as Article 1, Article 2, and the domestic adoption laws, we submit that these would extend only to Filipino citizens under the Philippine law, and in this case, the marriage of Nico and Lorenzo would fall within the ambit of Article 26 of the Constitution, of the Family Code, rather. And in addition to that, Article 26 does provide that foreign marriages solemnized in accordance with the laws attended in that foreign country, then they are also likewise validly recognized under Philippine law unless they fall within the exceptions as provided by that rule. Now, it is evident that although Article 1 and Article 2 do delineate a marriage as that between a man and a woman, it is interesting to note, or rather, it is notable that the framers of the Family Code did not include that requisite of the marriage having to be between a man and a woman under Article 26. The petitioners posit that this requirement would only extend up to Filipino citizens, and in this case, since Nico and Lorenzo validly solemnized their marriage in accordance with the California law in their capacity as American citizens, then what we have before us is a valid foreign marriage that is solemnized in accordance with those laws, falling within the ambit of Article 26. Yes, Your Honor.
Another conflict of laws. I know you mentioned Lex Loci celebration.
Yes, Your Honor.
Lex celebration of marriage. Is there an appreciation of an exception when the parties that got married appear to have evaded the national laws by having their marriage taking place in another country that would admit maybe a same-sex marriage? I think there's a US case called Valid State on that. So shouldn't this apply in our instance? Because it seems that Nico and Lorenzo tried to avoid the Philippine proscription on same-sex marriage by deliberately evading and going to another jurisdiction, correct?
No, Your Honor. We submit that Nico and Lorenzo, although they did have their marriage solemnized under American law, they did not renounce their Filipino citizenship or being under Philippine jurisdiction, since they chose to live together in Parañaque and raise their child under the Philippines. Or in the
Well,
Philippines.
then under conflict of laws, then the laws of their nationality should follow,
Yes, Your
including what Chief Justice Santa Maria was mentioning earlier.
Yes, Your Honor. The rules on the family rights and duties of Philippine law still do apply to them. And in this case, the petitioners posit that Article 26 is what is applied with regard to recognizing their foreign same-sex marriage. And in this case, there's no inconsistency or disharmony of this law with any other laws in attendance.
Was there any action filed by Lorenzo?
Seeking to recognize that there's a California court judgment, right?
Yes, Your
Was
Honor.
there any Rule 39 action filed by Lorenzo?
Your Honor, Lorenzo did not file for a judicial recognition of such. However, the Supreme Court has ruled, or rather has relaxed the rules on the procedural laws, on their procedural requirements in pursuant to substantive justice.
You mean the Supreme Court can take judicial cognizance of an unrecognized foreign judgment and say, well, we know it exists. We will just trust in the parties that it is what it is, without having undergone the whole recognition and enforcement process. Isn't that dangerous? And what's the precedent that you're citing?
Your Honor, the President, firstly, it would not be dangerous because this has been exercised previously in the Supreme Court, that they've relaxed rules on procedural rules and of its people under the laws. And in this case,
Then your
the
invocation
state
is wrong.
But the state still recognizes the Equal Protection Clause and that and the
Can you cite a precedent therefore? Case law, jurisprudence, where the Supreme Court has once upon a time invoked the Equal Protection Clause in terms of extending the benefits of a law to other covered individuals.
Your Honor, although I cannot assist you with regard to any case law specifically, the Equal
Why
Protection Clause
not?
still does provide.
You're here before us. Shouldn't you be ready with the case law that would support your argument?
Yes, Your Honor. However, the Equal Protection Clause
Doesn't
still
the
provides
case
the
of Republic
protection.
versus Manalo ring any bell to you?
This council does not know of the Republic versus Manila However, with regard to equal protection clause, once again, there is no substantive distinctions between heterosexual marriages and homosexual marriages. And
Counsel, did
therefore-
I hear you right that you're not familiar with the case of Republic versus Manalo, where the Supreme Court actually applied the principle of equal protection in terms of extending now the benefits of divorce to Filipino citizens, even if those divorce decrees were obtained and initiated by Filipino citizens?
Yes, Your Honor. I cannot assist you with that moment. However, with regard to, or with respect rather, to the parentage of Lorenzo over X, these such can be recognized under our Philippine courts for two reasons. First is that the petitioners posit that the renunciation of the parental authority that Janine had done over X is analogous to the renunciation done in an adoption.
Oh, leaving behind equal protection clause, counsel, how about the renunciation? Would it be a valid waiver under our Philippine laws?
Yes, Your Honor, it would be a valid waiver. Because in this case, the requisites of a valid waiver would be an existing right, and the...
What's your legal basis for saying that that waiver is valid under Philippine laws?
Your Honor, since the requisites of a valid waiver were met, which is that the party has an existing right, knows that existing right, and intended to waive that right, then the waiver was valid. And additionally,
But the
Article
waiver shouldn't be
210
contrary to contrary to law, public order, public policy. It is
Yes.
still the policy of the state not to recognize same-sex marriage.
Yes, Your Honor, and then the renunciation of Janine of the parental authority she has over X. This is still not contrary to any laws or any public policy. Specifically, Article 210 of the Family Code, although it does state that parental authority cannot be waived unless otherwise authorized by law. The petitioners submit that since the renunciation was analogous to that of a renunciation pursuant to an adoption, then it was validly wavered. Janine validly renounced her parental authority over X, and therefore the parental authority was transferred over to Lorenzo and Nico. Now, the courts may take note of the fact that the end of...
Counsel, what's your legal basis for saying that adoption is the same as surrogacy?
Your Honor, the petitioners posit that it's not on all fours equated to adoption. However, it is analogous in the sense that the end of adoption and the end of surrogacy is providing for an abandoned
Do you have
child a
any
permanent
legal
home.
basis for that jurisprudence?
Your Honor, Article 9 of the Civil Code does provide that a court cannot decide to, or rather decline to render judgment on the basis of an absence or insufficiency of laws. And in this case, the adoption law would be the most analogous to the surrogacy agreement in terms of that the end of adoption and the end of surrogacy is the same, providing an abandoned